Right, just setting up the stream here. I'm not sure if I am live or not. Just check my phone. No one in chat. Or no one saying anything anyway. Bear with me. I'm just letting the stream populate. If there is anyone in here, I'd be grateful if you'd say something in chat. I mean, it's possible the piece of software that I'm using isn't picking that up, so I'm just going to check my phone to see whether we are live or not. Looks like we're live. Looks like I've got some people watching. Okay. It's possible the piece of software that I'm using isn't picking that up. There we go. Right. Okay. Right. Direct D has posted another court video. And, well, obviously this is probably contempt of court by him. I haven't watched this video, but I thought I'd go live and watch it with some people. And let's just start now.
This is case number 22-0054491, State of Arizona versus Christopher Ruff. Mr. Ruff, first of all, I would advise you, if you are recording, to please not. If you're not, then we're going to go ahead and have a hearing on whether you have the opportunity to record at your pretrial conference on Wednesday. And I have received notice that you're requesting to use a smartphone to record your pretrial conference.
So I think I heard her say that she didn't give him permission to record. Let's just go back.
Conference on Mr. Ruff, first of all, I would advise you, if you are recording, to please not.
I would advise you, if you are recording, to please not.
Say, and I have received notice that you're requesting to use a smartphone to record your pretrial conference. Is that correct?
I have a personal one.
Well, it's a smartphone, correct? Okay, and is your personal audio recording device only?
Yeah, I'm going to call it right now. I think I found the single
Sorry
biggest
about the
productivity hack of
ads.
2020.
I'm going to give
It's
him
this
ads
Google Chrome
because
extension
I
called
am using his
A
material.
device that only records audio, has no other function. Okay, but that was not what your request was from Mr. Because your request specifically asked if you could use a smartphone, right? So now.
So it appears that he requested to use a smartphone, obviously with all the functions of a smartphone, but in court he's saying I think he's got an audio recorder.
Now you're changing it to just using a audio only. Am I understanding that correctly?
For the record, I am allowed to use a smartphone per 122.1. The definitions of a personal audio podcast are covered in the cell phone. It can be used as a function only to record and not do anything else. It also provides a provision in the rules for the court to make sure that I'm only using an audio recording function on the cell phone. Make sure.
Right, okay, I heard the end of that. I don't know if you picked it all up. The fact that he's recording himself, I'm surprised that the quality of his recording of himself isn't better, but hey ho. And he's just ended that with that he is recording using the audio recording of his smartphone. Sorry, the audio recording facility of his smartphone.
I am perfectly aware of the rules. I don't need you to tell me what the rules are. I have questions.
The admonishment, you don't need to tell me what the rules are. But, I mean, I will give it to Direct-D. He is an alpha male. I believe he probably is an alpha male. I mean, Delete Laws seems to have some battle with him that Delete Laws is more alpha than Direct-D. Well, I'm sorry, Delete Laws, but there's no contest, is there? Direct-D wins all the time.
About what your intent is. Okay, and we can go back and forth. I know you know the rules, I know the rules, so we're going to follow the rules. Okay? You put in a request, a records request, and that request was made. And let me see. So I have the dates correctly.
Judge seems well prepared.
All right, and I would also note if either of you are recording, I would direct that you are not allowed to record in the courtroom.
So there are obviously two people in the courtroom, and she has asked them again, both not to record. And yet, somehow, I don't know how, we have an audio recording appearing on the internet.
Okay, so on June 1st, you sent in a records request across the street to the records department over across the street, who forwarded over to us, where you had indicated, you indicated that you wanted to audio record, etc. And then at the end of that, you say, my question is, can I use my smartphone to record my court appearance after giving the judge notice? If not, I would like the statute that restricts my recording. So that was your question, asking for a smartphone. So when you were requesting whether you can use a smartphone is different under the definition of an audio recording. If you look at the specific rule, it says that a personal audio recorder is a device used to record audio only. So it only records audio.
Now that seems pretty, straightforward to me. It's an audio recorder, and that's its function. Has no other functions.
If you look at the definition of a recording device, it talks about an electronic or mechanical apparatus
Sorry, I ignored you.
Related to equipment used to capture or sound images or both, or from which a person can retrieve or broadcast sound or images. A camera, a smartphone, and an audio recorder are examples of recording devices. So if your intent is to just use an audio recorder only, not a smartphone, not a device that has a function other than simply recording audio, that requires us to
Mark, I don't care where you are.
Because they have
I
an
really
opportunity to object if they choose to. Any witnesses or victims or
I hope you're okay,
anyone involved in the case from the state side has a right to object. And if that happens, then
I'm glad you're still on this earth.
They have a right to make that statement. And the court has to hold a hearing and allow that opportunity. So that's the purpose of today's hearing. is to determine if and under what conditions you would be allowed to record and what type of device you would be allowed to use.
Sorry, I did speak over her a bit, but it seems like we got the conclusion there that this is just a hearing to see what device he can use, and he's already been told that he can't use a device to record this hearing. So, what, he's in contempt of court, probably? Who knows, I may be in contempt of court for doing this stream, but hey-ho, I'm across an ocean.
So, if you're telling the court that you are intending to only use an audio device, that is a different situation than using a smartphone or some other.
Sorry about the
Welcome
ads.
to Reich Gantt
As I
charts.
said before, I'm going to give
Break
him
complex project plans.
the ads. I don't like putting an
Device
ad blocker on
that does other
when I'm
functions.
streaming someone
So I
else's
think
stream.
that's where we need to first start with our inquiry.
Okay.
Because that will determine where we go. So do you have like just a device with just audio only, not a smartphone?
The question was this.
Sorry, Mark, hang on. I'm just going to talk to Mark in chat. What did you say? Did you find me yet? Or no, obviously, but I don't really care. It was quite fun tracking you across the country. Salt Lake City area was lovely. I loved the scenery there. But I don't know what. No idea where you are. What, are you across an ocean from me? I suspect so, Mark. I don't know. Probably you are somewhere on the west coast of America, or possibly you're making your way back towards Sioux Falls. Who knows?
It's more of an understanding of how the rules are written, because I'm not going in Tempe courts, I'm also in Mesa, Maricopa County, and Gilbert courts, and this is the only one that's trying to find it. So
Okay, well, I can't tell you what another court does or what they don't do. I'm looking at the rule, and I'm reading the rule. Right.
That's not how it works.
Okay, well, let me just say,
Written specifically, and a cell phone is a personal audio recording device, but you're right, it's moved, I do have a personal audio recording device. Anything else, but my company court, I'm just gonna notify you and stuff.
just let me tell you that you also have a remedy if the court denies it. You always have a right to appeal it.
And you heard him. I mean, you don't do yourself any favours, I don't think, when you're interrupting the judge when she's telling you something and you argue back. But hey, that's DirectD's personality. As I say, is now for male, definitely compared with delete laws. So he was saying, well, he could record elsewhere, so he can record in her court. Well, she controls her court, and she will rule how she rules, and as she said, you can go and appeal it.
Versus a special action.
And I'm sorry for the audio quality of his voice. It's very hard to hear what he's saying. And as he's put the video up, I'd have thought he'd have sort of corrected his own voice by translating for us. Or
You have a remedy if I prevent you from recording or using a device. So that's your right. I don't know what Mesa does. I don't know what Chandler does. I don't know what Gilbert does. I can tell you my interpretation of the statute, and it specifically gives definitions of what a personal audio recorder is and what a recording device is, and it tells the rules for each of those items. It also specifies that it's up to the judge to determine whether or not, after making specific on-the-record findings, there is a likelihood of harm arising from one or more of the following factors, and the harm outweighs the benefit of coverage to the public.
so she's setting out her court and the court-specific rules pretty clearly, I think, there. Which is easier to understand than Direct D was. And let me just look at chat while I'm... So, fuck the police, as I say. Happy you're still with us. Mark, Cop Block Hot Strings, Hiya, Big Bang, I am back, Pilot, thanks for joining.
So that is the purpose of a hearing. Now you have demonstrated on 2 separate occasions in this court where you have vagrantly violated the court's instructions. It has been brought to the court's attention that you have gone out to the front counter, you have taken pictures of staff indicating to them that you were posting their images online.
But it's his building, Judge. You can't say that. He pays for it, and you're his servant.
You have made statements in the courtroom that you were going to post things online, and the court's concerned about that. Because I, the judge, have the responsibility to uphold the dignity of what goes in this courtroom, to protect the privacy of anyone in this courtroom. And I will note that a pretrial conference, it is just not your particular setting. There are other people in the courtroom. There are potential victims in the courtroom.
Hang on, there was a question in chat there. Fuck the police. I am good. I am back, sorry. Good try, though. Sorry, I got your whole name. I missed the whole name. Who is Fuck the Police? Hi, retired road dog. FTP is Mark Burgess out of Sioux Falls. He hit the auditing scene when James Freeman was around and Mark got tackled to the ground. And that was the first instance of Mark appearing. Now, from the outside, it appears that Mark does have some sort of mental health issue going on. And so there is a lot of forgiveness for you, Mark. You know, there's something going on, Mark. I wish you well. I hope you get the help that you obviously need. Although if you feel that you don't need it, don't go and do anything stupid. That is Fuck the Police. Hi, Auditron.
There are other defendants in the courtroom that would violate their privacy.
And you fully propose for whether.
Well, you have a remedy, as I explained. So I am going to make a finding that if you are using an audio recording device only, it cannot be a smartphone, it cannot be a device that has any other function. You will be allowed to use it only when your case is called, and you need to turn it off as soon as your case has been addressed by the judge.
So, my understanding of freedom of the press and restraint, the judge has given him an ideal way and is allowing him to record his hearing. I mean, I don't know what an audio recorder costs, but it can't be much more than 15, 20 quid, I should think. So why the hell he's making a point about this, I have no idea. The judge is giving him permission to record future hearings. Now, it must be remembered that she didn't give him permission to record the hearing that we're currently watching. For those that have just joined, she said right at the outset, you are not to record this.
That's fine, sir. As I explained, you have, sir. No, they cannot.
Yes, they can.
They have to go through the same process you do, sir. Okay, sir, we can argue. We can argue about this. It's not going to get us anywhere. So you have a remedy. You can certainly exercise that remedy. That's my finding. I am limiting that to that. And I'm also noting that if it comes to the court's attention.
Asked in chat a finding based on what? Well, she did actually explain earlier the rules that her court works under. So it's based on the rules that her court is working under. Now, you ask a good question, Cockblock Hot Springs, and it comes to the basis of what is the point of this activism. Now, is its point for clicks and views and to make money? Fine, just say that. Is its point to actually prove something or change something? Then if you disagree with these decisions that are being made, rather than ignore them and, you know, risk contempt, which basically is doing, he has a remedy. He can appeal the decision, and then he can appeal the decision. So, and that's how your US law is formed. I mean, judges make decisions based on courts of appeals and Supreme Court's rulings. That's what they are making decisions on. And also, of course, back to the statute. So, I just don't get it, you know. Just don't commit contempt to court. I mean, it's fun for us because we go to watch or hear the audio, although it's not very good from DirectD, but
that you are broadcasting any of the things in this courtroom, that is potential for contempt of court.
There you go, contempt of court.
For the record, I am a reporter. Anything that I do record on this program is going to be posted to the internet.
Okay.
For my rights.
Okay.
I wish I could understand what he said there. DirectD, if you're going to do it, make sure that you do a decent recording of yourself as well.
Well, with that said, I'm going to deny your request to record, period.
You can't do that.
I can.
This game,
Right.
you're not ready for.
Sir, and I am denying it. And for the record, I am denying it under.
So, DirectD, I think, said he was going to defy the judge's order. I mean, that's not a sensible thing to do, probably, to the judge. So, the judge having given him permission to record on an audio recording device, so a device that can only record audio, he said he doesn't accept that and he's going to do what he wants. Well, I suppose that's what makes you alpha, DirectD. You do what you want, but unfortunately you live in a land of law.
Rule 122, subsection, excuse me, sir, but I would appreciate not being interrupted. I am denying under subsection B of 122 and under subsection G, 1G.
I think what I'm going to do is I'm going to try and get down this subsection that she's making the denial over, and if I get it, I'll either post it in a community post or just do a short video.
Under the denial of coverage, I am denying you the ability to record in any fashion.
Hi, Nasty.
Based on your prior
Thanks for that comment.
conduct and based on your statements.
So what are you going to do if I pay $17 for the audio that you just recorded right now? I'm gonna-
You can certainly do that if you want, sir.
So it's a power trip right now. You're using your authority and and accepting the judicial.
All right, sir. This matter has been concluded.
I think probably it's so hard to hear what he's actually saying, but I think you just get the impression of the man that he's probably had a problem with authority all his life. An authority tells him that he can't do something, and in the past he has ignored it, and in the past this has led to a felony sentence, which he served, and obviously he's bitter about that probably as well. But rather than learn his lesson that he lives in a land of laws, and it isn't his interpretation of the law that matters. He can read a law and interpret it, he can pick out words and say this allows him to do it. But often that's not the case. And if he thinks he's right, he needs to take the next steps and appeal. Do the complaints. Follow the procedure through. I mean, I know I've got Nasty in the chat. Now, generally, Nasty complies with, well, I think probably all the time he tries to comply with the law. Nasty himself. I think you're a felon, aren't you, Nasty? I have no problem with him being a felon because he's a reformed felon. He understands that he lives in a land of law.
That's everything.
Okay, and you have a remedy. You have a remedy. Court will be in recess.
Well, I hope you enjoyed that stream. That's the end of the video. That's all I intended. That was my first watch of the video. I don't know if I said anything controversial. I'm going to look up that section if I can find it that she made her finding on that removed his right to record. He's obviously put this on the internet. Be interesting to see if he's held in contempt at some point. She seems fairly lenient, actually. The fact that she knows that he has done something that is prohibited but has let him off suggests, I don't know how many chances she'll give him, and maybe this video will be the one that gets him. But hey ho, it's his life. And if he's right, and this is a First Amendment matter, well, let's see his case go through the federal courts to prove his case. Cheers, Nasty. I'm going to say bye now because I think that's it. I didn't know that he posted this. I saw a community post that he'd done about prior restraint, and he thinks that this judge has put prior restraint on him. Now, in many courthouses, as you know, in many courthouses in the United States, you cannot record. They won't let you record. If you think that the First Amendment gives you that right, why do you think that there aren't many cases that have gone and then eventually been taken to the Supreme Court to affirm that right? You don't have the right to record in court. The court decides based on the local rules, the local laws. It's not against the First Amendment, in my opinion. My opinion is probably not worth anything, being the other side of the ocean, but being the other side of the ocean enables me to probably, I don't know, am I in contempt of this court? I don't know. By rebroadcasting this? I don't know. Do I care? No, I don't.